and then there are other things that are important in that MSA or the addendum that get attached to the MSA, like automatic price increases, especially after we've gone through this inflationary period. I
Mm-hmm.
can't tell you how many times people come to me with their MSA and they have not increased their price in 7 years, 8 years,
Right.
10 years. It's
Right.
crazy.
Folks, it is a privilege to be sitting down today with Thomas Fafinski at Virtus Law to talk about legal topics MSPs should be thinking about when looking to sell. Virtus Law was founded in 2010 and is a nationally recognized firm that focuses on the MSP space. Thomas and his partner work regularly on MSP transactions and are a common fixture at MSP conferences and at MSP peer groups, speaking and advising MSP owners on the legal issues that keep them up at night. Listen in here and follow Thomas at www.virtuslaw.com. But first, before we go any further, let's get some housekeeping out of the way. My name is Madhur Dugar. I work in the IT and software M&A space, and this is my podcast series, M&A Insights. If you are interested in having a conversation around the strategic direction of your firm, are looking to grow your book and want some marketing and business development help, or are an investor looking to make an acquisition in the space, write to me at podcastwithmadhur, that's MADHUR, at gmail.com, or reach out to me on LinkedIn. What should MSP owners be aware of regarding client and vendor contracts when preparing for a sale?
Yeah, that's a great question because when you look at the assets that a buyer is buying, it's really truly it's two assets, two groups of assets.
Yes.
One is your customer contracts,
Yeah.
and the second is your employee relationship. I mean,
Yes.
everybody is just struggling to find the right employees to work for them. So when you
Mm-hmm.
go buy, a company and it's got, 20 employees and they have been there all for 3 years, you're like, "Hey, they must be good," right? So it's almost like avoiding headhunter fees. So the MSAs become a really critical part of the analysis, and there are features of an MSA that are attractive to buyers. So one feature is you want to have a truly umbrella-like MSA, an MSA that says, "Hey, you're our customer, and these terms are gonna apply on anything we do, whether it's, you know, monthly recurring, the monitoring components, whether it's a change in location, like a project-based thing,
Mm-hmm.
or or virtual chief technical officer type services, or it's a voice over internet telephony solution. Whatever they're doing, we want that to be under these terms.
Mm-hmm.
So I think that if we can get this umbrella-like MSA that covers some of these pieces, that it becomes far more attractive. I think it's easier
Mm-hmm.
not just to sell your company, but to sell your services.
Mm-hmm.
Instead of the traditional way of doing it, and what I see, hopefully it's changing, but hopefully it will continue to change. But normally what I see are transaction-based contracts. So think of it like you're engaging a a builder to build your house, and you say, "Here is the plan that we're doing, and here are the specs and all that stuff." And it's a picture in time of a transaction that folks are doing. Same thing is true like when you hire an attorney. Like if you hired me to do an MSA, I would not send you over an umbrella retainer agreement. I would send you over a retainer agreement. And what we want is something that is more like instead of a picture, we want it to be a video. We want it to
Mm-hmm.
continue to add and be alive. And as buyers of business, if you see that happening, you know that the customers have been trained to purchase additional
Mm-hmm.
services. So I like to see that umbrella format. Of course, we have to have an assignment provision in that
Mm-hmm.
umbrella agreement that allows us to sign in the event that we sell.
Mm-hmm.
And then there are other things that are important in that MSA or the addendum that get attached to the MSA, like automatic price increases, especially after we've gone through this inflationary period. I
Mm-hmm.
can't tell you how many times people come to me with their MSA and they have not increased their price in 7 years, 8 years,
Right.
10 years. It's
Right.
crazy.
Right.
They're doing the same amount of work and inflation is eating away at their
Yeah.
profit. So if you have, this price increase, automatic renewal, most people do the automatic renewal piece, termination fee. So our customers are, speaking as an MSP, our customers are being acquired.
Yeah.
And when they get acquired, oftentimes, if it's like private equity or a strategic uh, buyer, they say, hey, we got our MSP that we've been working with for years
Yeah.
and they're going to do the work. So we're terminating. So the MSP that's servicing the seller has done nothing wrong. And they
Yes.
are fully invested. And the way that these contracts are structured, it's back end loaded. You don't really make that much money in the first year that you have a customer. You really make the money in the latter years. So if they're terminating and you're 18 months in, and they're terminating because they're being bought, you're like, I hardly made anything on this.
Mm-hmm.
This is crazy. So, I think termination fees are appropriate. Another common reason why and your listeners will probably be going, yeah, that's another reason why they do it. So it's the sale of the business, and it's also a change in the CFO seat. When there's a new
Okay.
CFO or COO, so CFO or COO, new person comes in, hey, we're
Yeah.
doing great. We had to add this person. They're like, I was over here and I worked with this MSP. I want to change. So
Mm.
we want to create a disincentive for the owner of that company to
Switch the
make the
MSP.
change, and have
Yeah.
a termination fee.
Yeah. How often do you see termination? What fraction of the contracts that you see you think have termination fee built in them?
The contracts that I see coming to me,
Yeah.
uh, very rarely do they have a termination fee.
You put them in there.
The
Yeah.
contracts that I do for people,
Yeah.
it is rare that they don't have a termination fee.
Right.
No, that's not termination for cause. Like if you did something wrong,
Right.
or
Yeah. Yeah. Yeah.
that
Yeah.
kind of thing.
Yeah.
But and the
Very
termination
interesting.
fee can't be 100% of the contract because
Right.
judges
Yeah.
they're not going to
Yeah.
enforce that. Yeah, and I like to tie it to like 50% of whatever the
Oh,
remainder of
yeah.
the term
Sure.
is.
Very logical, right? Because then you're looking at the actual economic impact of that and then tying it to that.
Bingo.
Um,
And that's what a judge will look at. Judge is going
yep.
to look at, does this accurately reflect what you
Yep.
lost? And when you go to
Yep.
a judge and you go, actually, judge, it does because my gross margin is 45%. That's not my profit margin, but that's my gross margin. So my margin on this project is 45%. So I'm just trying to recover my margin.
Yeah. Fair enough.
That MSA should have a limitation of liability clause so that the buyer knows that damages are going to be capped. In order to truly make a limitation of liability clause enforceable, you probably have to have a remedy other than just a capped dollar amount. I like to say, hey, it's capped at X dollars or X number of months or whatever, uh, unless it's covered under insurance. So
Okay.
if there's an insurance policy that provides coverage, and most judges are going to enforce that limitation of liability if that
Okay.
provision is in there.
Yeah.
There's one of the newer things that I'm doing. I don't know anybody else that's really doing this, but one of the newer things I'm doing is embedding a declination of services inside the addendum that people are signing for the monthly recurring. So when they say we don't want to have um, BDR,
Mm-hmm.
in the past, what would happen is you would look at the addendum and BDR just wouldn't be mentioned.
Mm-hmm.
And now I have kind of migrated to, let's reference that BDR is not being included
Mm-hmm.
so that when we do our periodic business review, that client is looking at things every month and saying, hang on a second, maybe I ought to be doing that.
Yeah. 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 It's a good point. Yep. BDR is not
So
in there. I'm reminding you again and again. BDR is not in there. It's not in there. Yeah.
yeah. And so the last piece I think I look for when I'm representing a buyer when it comes to the MSAs is I told you that, the other big asset, the biggest asset is, or not the biggest asset is the MSA. The next biggest asset are the employees. And it's a
Mhm.
close second. I mean, they're
Mhm.
pretty neck and neck. So in the MSA, I like to see some sort of penalty for hiring away our techs. And so judges don't like penalty damages, they're called liquidated damages.
Mhm.
So rather than have it be a penalty, several years ago, I moved to creating a placement fee provision so
Okay.
that in addition to being an MSP, you're also a placement service. We will provide you with our employee if
Okay.
you so select, but the placement fee is, you know, X percent of their scheduled compensation for
Yeah.
the last 12 months or something where you
Clever.
get something, if they're making 100 grand, you're getting 50 grand because they hired. Now, that's justifiable because, recruiters are charging 33%
Mhm.
oftentimes for placing talent without having them come in trained or acclimated to the environment. So you're not
Yeah.
only, providing the talent, but it's acclimated. So that
Mhm.
is, that's probably it when it comes to the MSAs that I'm looking at when I'm
Mhm.
representing the buyer. If a seller comes to me and says, "Hey, I want to prepare for the sale," I say, "These are the things that you need to have in your MSA." Then you turn to the employees. And there's two types of employees. There are, and I guess it's a, scale of, it's more of, clearly there's the staff person that doesn't matter as much as technical people that matter a lot, and then there's probably people in the middle. But
Mhm.
broadly speaking, there's two categories. I call them key employees and non-key employees.
Okay.
For the key employees, you want to have some sort of retention mechanism so that it is likely that they will stay on with the buyer.
Mhm.
You also want to have a history with them. You want to have 2 years of employment with them, um, with a raise that is, my typical raise scenario is if you start working with me, um, in a year you'll probably get a 25% increase, and then at year two you'll probably get a 15 to 20% increase. And I tell people when they come work for me, I say, if you don't get those raises, that means I don't think you're doing a great job, and you should probably start looking for another job. So they know, hey, I only got an 8% raise, so that's more like cost of living, and I
Clever
should.
again. Yeah.
Unfortunately, you can't really do that in the MSP world,
Okay.
but you want to have some sort of, double digit steady raises, for these folks that plateau.
Mhm.
And so it's not, the trajectory of the increase has stopped.
Mhm.
Um, the One of the best ways to ensure that they stay is to create some sort of synthetic equity
Mhm.
that they get to participate in the sale, and then
Mhm.
delay the payment of the synthetic equity, to coincide with the release of the indemnification escrow inside
Mhm.
of an M&A transaction.
Mhm.
Um, there's a great reason for that. One is, you want to fund it not from the closing dollars. You want to fund it from the after closing dollars. The other piece is if the employees know that they're getting paid from the indemnification escrow, they're going to try like heck to make sure that the escrow passes without getting.
Mhm.
On the employment contracts, non-competes are disfavored,
Okay.
but I address it a lot of times. We can do a non-solicit where we
Mhm.
say, you agree you're not going to reach out to any customer that you served.
Yeah.
We can address it with confidentiality provisions,
Mhm.
and so the confidentiality provisions are harder to enforce, but we can actually take our policies and procedures and go register them as copyrights and
Okay.
prevent them from being used by others, as a registered copyright. That takes
Okay.
some forethought, but if you have processes and procedures in place, you can do that. Or you could scare them and just say they're copyrighted, and and hope that they understand, oh, I get in trouble if I do that.
If I do
And the
that.
confidentiality piece is a really important piece because and to have that broadly defined to include the identification of customers,
Mm-hmm.
because in some jurisdictions it's not allowed to have non-solicits even.
Okay. Yeah. Um, and then how common do you see situations where, the buyer is going to say, listen, this key employee, not only can they not solicit clients, they can't start their own firm or even address clients in anywhere in the US who are potentially my clients. Like how do you scope that?
So I normally don't scope it for anybody that's a non-client unless
Okay.
it's really local, and normally you have to be a pretty small MSP to have that. The
Yeah.
geographic restrictions that are broad are really subject to attack.
Okay.
And so I kind of look at it like, hey, we're gonna look at the customers that we already serve.
Thomas, thank you so much for a really
Oh,
incredible conversation. I really
thank you for
appreciate it.
having
I think this was very, very useful. Insights on the legal side. I think my audience would really love to hear that. So I appreciate it. And yeah, I hope to stay in touch and maybe do another one of these in the not too distant future.
me. Sounds great. Thank
Yeah.
you, my friend.